$412,000. That's the number I kept staring at on my laptop screen at 1:47 in the morning in the blue light of a spreadsheet I wasn't supposed to have. $412,000 quietly moved over 11 years out of my in-laws' estate and into the pockets of one person, not split between their two children, not divided the way any estate planning attorney would tell you to divide it. All of it funneled to one son, my husband's brother. I want you to sit with that number for a second, because by the end of this video, you're going to understand exactly how it happened, who helped make it happen, and, this is the part that's going to make you want to stand up and cheer, exactly how we got almost every single dollar of it back. My name isn't important right now. What's important is this. For 11 years, I watched my in-laws, a retired school teacher and a semi-retired contractor from Central Ohio, quietly hollow out their own retirement to prop up their golden child. And when my husband and I finally asked a simple question, where did the money from Grandma's house go, we were told, and I quote, "Some things aren't your business." They thought we'd just accept it, write it off as favoritism, grit our teeth through another Thanksgiving, and let it go the way families do. They thought they got away with it. They were wrong. Before I get into it, let me tell you what this video is really about, because it's bigger than just my family. This is a story about financial elder exploitation, a crime that costs American seniors an estimated $28 billion a year, according to a study published by the Consumer Protection Bureau. Most of that money, nearly 70% of it, doesn't come from strangers running phone scams. It comes from the people closest to the victim, family members, the people you'd never suspect because they're already inside the walls. This is a story about greed, about betrayal, about a golden child who thought the rules didn't apply to him and two aging parents who let him believe it. And it's a story about getting every single dollar back through forensic accounting, through public records requests, through adult protective services, and eventually through a courtroom.
If you're new here, I tell true financial justice stories, real accounts of people who got scammed, exploited, or betrayed by someone they trusted and fought their way back. If that's the kind of story that gets your blood boiling in the best way, hit subscribe, because we've got a lot of ground to cover today, and I promise you the ending is worth the wait. Let's go back to the beginning, because to understand how someone loses $412,000 without realizing it, you have to understand how the trust gets built first. I married into the Whitfield family. That's not their real name. I've changed it along with every other identifying detail in this story for legal reasons you'll understand later, in the fall of 2013. My husband, I'll call him Danny, was the second son of Robert and Diane Whitfield, a couple who'd built a modest but genuinely comfortable life in a town outside Columbus, Ohio. Robert had run a small general contracting business for 32 years, decks, additions, the occasional kitchen remodel. Diane taught 4th grade for 26 years before retiring with a pension. They weren't wealthy in the yacht and vacation home sense, but they were what a financial planner would call asset-rich, cash-modest, a paid-off house worth around $340,000 in a good school district, roughly $180,000 in a combination of a 403(b) retirement account and a small IRA. And, this is the piece that matters most, Diane's mother's house, which Diane inherited outright in 2011 when her mother passed, worth about $210,000 free and clear. Add it up, and you're looking at a family with a net worth in 2013 of somewhere around $730,000. Not extravagant, but real. Built slowly, over decades, the way most middle-class American wealth is built. One mortgage payment, one pension contribution, one inherited house at a time. I want to spend one more minute on Robert and Diane themselves because understanding who they were as people matters for understanding how this happened to them specifically. They married young. Robert was 22,
Diane was 21, and by their own account spent the first decade of their marriage in a rented duplex, saving aggressively for the down payment on the house they'd eventually die in if fate had gone the way it should have. Diane's father had been, by family legend, a difficult and financially reckless man, and Diane had built much of her own adult identity around not repeating that pattern. She balanced a checkbook by hand well into the 2010s, kept receipts in labeled envelopes, and famously never carried a credit card balance in her life. That detail matters more than it might seem, because it's part of what made this so hard for Danny and I to see coming, and part of what made it so devastating for Diane specifically once she understood what had happened. This wasn't a financially careless woman who'd been an easy mark her whole life. This was a woman who had organized her entire adult identity around financial discipline, slowly, invisibly losing control of her own money to the one person she trusted enough to not double-check. And they had 2 sons. Danny, my husband, was the quiet one, steady. He'd gone into mechanical engineering, worked for a manufacturing firm, paid his own way through a state school with a mix of scholarships and loans he finished paying off by 31. He called his parents every Sunday. He drove the 6 hours to help his dad re-roof the garage. He was, by every conventional measure, the reliable son. Then there was Marcus. I need to be careful here because it would be easy to just tell you Marcus was a villain from day one, and that's not quite true. Or at least it's not how it looked from the outside for the first several years I knew him. Marcus was older than Danny by 3 years, charismatic in the way that certain people just are, the kind of guy who remembers your kid's name, who tells a joke that lands, who shows up to a party and somehow becomes the center of gravity in the room. He'd bounced through a few different ventures in his 20s and early 30s, a food truck that lasted 18 months, a stint selling commercial real estate, a consulting business that, as far as I could ever tell, consisted mostly of Marcus consulting himself into other people's money. Every single one of these ventures had been capitalized, at least in part, by Robert and Diane. The food truck, $22,000, described at the time as a loan that was never repaid and never really discussed again. The real estate license on the first 6 months of marketing materials and MLS fees while he built a client base, another $14,000. The consulting business, which Marcus described to the family as basically my own firm now, that one got $38,000 in startup capital between 2015 and 2016, ostensibly for a business license, a website, a co-working space membership, and a used Lexus that Marcus insisted he needed to look successful in front of clients. None of these were framed at the time as gifts to one son over another. They were framed as investments, as helping Marcus get on his feet, as things that would obviously even out later because that's what family does. You help whoever needs help in the moment. And here's the thing about that framing. It's not inherently wrong. Parents help kids who are struggling more than kids who are stable. I understood that. Danny understood that. For years, we didn't think twice about it because we genuinely didn't need the help, and Marcus, by his own account, did. That's how the trust gets built. Not through one dramatic moment, but through years of small, reasonable-sounding decisions that all point in the same direction. Looking back, and I want to be honest with you about this because I think it's the part viewers will recognize most in their own families, there were red flags stacking up for years. We just didn't read them as red flags. We read them as personality. Red flag 1. Marcus managed his parents' digital life. Somewhere around 2014, Robert and Diane got a little overwhelmed with online banking, and Marcus, tech-savvy, always around, set up their accounts, their bill pay, their passwords. He had, from that point forward, either direct access or effectively unsupervised access to their checking account, their savings account, and eventually a joint signatory role on a home equity line of credit Robert opened in 2016 to help with some renovations. We now know that access was never revoked, audited, or questioned by anyone else in the family for the next 8 years. Red flag 2. Marcus was always physically present. He lived 9 minutes from his parents. Danny and I lived 4.5 hours away. Marcus drove Robert to doctor's appointments. Marcus was there when the water heater broke. Marcus was there for the small, unglamorous logistics of aging parents' lives. And that physical proximity translated directly into influence. Every financial decision Robert and Diane made in their late 60s and early 70s passed through a filter of, well, Marcus thinks we should. Red flag 3. The narrative about Danny started to shift. This one stings the most in hindsight. Sometime around 2017, small comments started creeping into phone calls. You two seem to be doing just fine on your own. Marcus really needs the support right now, you understand? We know you'll be okay. You always land on your feet. It sounds like a compliment. It functions as a justification. Every dollar that moved toward Marcus was quietly reframed as fine because we, Danny and I, were framed as not needing anything. Red flag 4. Diane's mother's house. This is the one that 4 years later would become the center of the entire case. In 2011, when Diane's mother passed, Diane inherited her childhood home outright. For 6 years, the family rented it out, and the rental income went into a joint account. Then in 2017, with no formal family conversation that Danny or I were ever included in, the house was sold. We were told in a single sentence during a Sunday phone call that the house had sold for around $210,000 and that the money was going towards some things your dad and I have been wanting to do. That was it. That was the entire explanation we received for $210,000.
We didn't push, and I want to be honest about why. Because pushing felt greedy. It felt like implying we were owed something, and neither Danny nor I wanted to be the in-laws who showed up asking about money. So we said, "That's great, Mom," and we moved on. That instinct, the instinct not to ask because asking feels shameful, is exactly the instinct that financial predators, even unintentional ones, rely on. The moment I want to flag as the real turning point, the moment where favoritism started curdling into something closer to exploitation, was in early 2018. Marcus's consulting business had quietly folded sometime in 2017. He never announced it. We just noticed over a few months that he'd stopped mentioning clients, stopped posting the LinkedIn updates, and started describing himself, when asked, as in between things, exploring options. And within about 4 months of that consulting business folding, Robert and Diane, who at this point were 69 and 67 respectively, opened a new line of credit against their paid-off house, a $150,000 home equity line of credit, taken out in March of 2018. We were told this was for some upgrades to the house, maybe a new roof, updating the bathrooms. The roof was never replaced, the bathrooms were never updated. We didn't know that yet, though. In 2018, all we knew was what we were told, and what we were told sounded reasonable enough that we didn't ask a single follow-up question. That's Act 1. That's how 11 years of financial redirection starts, not with a scam artist and a stranger, but with a trusted son, a set of aging parents who loved both their children and simply loved one of them more actively, and 2 people, me and Danny, who were taught gently and repeatedly that asking questions about money was impolite. By the time we finally did ask the question that cracked this whole thing open, it was 2022, and the number wasn't $22,000 anymore. It was $412,000. Before we move into how this all came apart, I want to give you one more scene because I think it captures the emotional texture of Act 1 better than any spreadsheet line item could. Thanksgiving, 2019. Diane's dining room. The good tablecloth out, 12 people crowded around a table built for 8. Marcus arrives 40 minutes late. He was always 40 minutes late, with a bottle of wine that, I'd learn years later, cost more than his monthly car insurance payment. He tells a story about a deal that's about to close, something involving a commercial property downtown, something that sounds impressive in the vague way stories about impending success always sound impressive when you don't ask follow-up questions. Robert beams. Diane refills his wine glass before he even asks, and Danny, sitting next to me, leans over and whispers, only half joking, "Must be nice." I remember laughing it off. I remember thinking that's just how families work. Somebody's always the exciting one, and somebody's always the reliable one. And reliable doesn't get toasted at Thanksgiving, but reliable also doesn't need to be rescued.
What I didn't know sitting at that table was that the deal about to close was, according to what we'd later reconstruct, roughly the same period the forensic trace would identify as the beginning of the gambling pattern. The confident story wasn't marketing for a business, it was a cover story for a hole that was just beginning to open. That's the thing about financial exploitation inside a family. It doesn't arrive wearing a warning label. It arrives wearing a nice bottle of wine and an exciting story at a table where everyone wants to believe the exciting story, because believing it is so much easier than asking the question underneath it. In September of 2022, Robert had a mild stroke. He recovered, thankfully, fully, with only some residual fatigue and a temporary weakness in his left hand, but the stroke put him in the hospital for 6 days, and it put Danny and me on the road within 4 hours of the phone call, the same way it put Marcus at the hospital within 20 minutes, because he lived 9 minutes away and Danny and I lived 4.5 hours away. I want to pause here and say something important. Nothing about what follows is about resenting Marcus's proximity to his parents. Physical closeness to aging parents is a genuine gift, and if the story ended with Marcus helped more because he lived closer, this wouldn't be a story worth telling. What made this a story worth telling is what that proximity was used for. While Robert was in the hospital, Diane, rattled, exhausted, scared in the particular way you're scared when your spouse of 41 years has just had a stroke, said something to me in the hospital cafeteria that she almost certainly didn't intend as a confession. She said, "I just don't know how we're going to manage if something happens to him. There's just not as much left as there used to be." I remember exactly where I was sitting. I remember the fluorescent light humming over the vending machines, and I remember thinking, what do you mean not as much left? Robert and Diane had spent their entire lives being financially conservative. Diane clipped coupons well into her 60s out of habit, not necessity. The idea that there wasn't as much left as there used to be didn't match the family I thought I knew. I asked her gently what she meant. She waved it off. "Oh, don't worry about it, honey. Your dad and I are fine. Things have been tight, that's all." Things had been tight for a couple with a paid-off house, a pension, a 403B, and a $210,000 inheritance from 6 years earlier. That sentence sat in my chest like a stone for the rest of the hospital stay. I didn't say anything to Danny yet. Robert was recovering. It wasn't the time. But I started, quietly, to pay attention. Robert came home from the hospital in late September. Danny and I stayed an extra week to help. Meal prep, driving Robert to physical therapy, the unglamorous logistics of post-stroke recovery. During that week, I did something I'm not proud of and would do again in a heartbeat. I looked through the mail. Not snooping in a malicious way, I was helping Diane sort through a stack of unopened envelopes on the kitchen counter, genuinely just trying to help an overwhelmed 71-year-old woman deal with logistics while her husband recovered. But mixed in with the AARP newsletters and the pharmacy flyers, I found something that made my stomach drop. A statement from a home equity line of credit showing a balance of $147,000, nearly maxed out on the $150,000 line they'd opened back in 2018, with a minimum monthly payment of $1,140. I also found a second statement from a personal line of credit at a different bank, one I'd never heard of before, showing a balance of $31,000. And I found a letter, this one I almost missed, tucked in an envelope from the county recorder's office, referencing a durable power of attorney for financial matters that had been executed and filed 8 months earlier, in January of 2022. Robert and Diane had given someone power of attorney over their finances, and neither Danny nor I had ever heard about it. I didn't need to guess who. I told Danny what I'd found that night in the guest bedroom, in a whisper, because his childhood home apparently was not a safe place to talk about his parents' finances at a normal volume. Danny's first reaction, and I want to honor this because it's such a human reaction, was defensive. Not of Marcus, of his parents. Maybe it's nothing. Maybe Dad just wanted someone local in case of an emergency. That doesn't mean anything's wrong. He was right that it didn't necessarily mean anything was wrong. A power of attorney by itself is a completely normal and often wise estate planning tool. Every elder law attorney will tell you every adult should have one. The problem isn't that a POA existed. The problem, as we'd learn, was who held it, how it had been obtained, and what it had been used for. The next morning, Danny asked his dad directly, as gently as he could, "Hey, I saw you and Marcus set up a power of attorney. Is everything okay? Should we be worried about anything?" Robert's answer was 3 sentences, and I remember every word of it because it was the first time in 9 years of marriage I'd heard my father-in-law sound genuinely uncomfortable. "Marcus handles that stuff now. It's easier with him being close by. You don't need to worry about it." That was it. No explanation of terms, no mention of what accounts were covered, no acknowledgement that maybe, given that Danny was also a son and also an adult, he might have been looped in on a decision this significant. We let it go, again, because Robert had just had a stroke and it felt cruel to push a recovering 74-year-old man into a financial interrogation. But something in me had shifted. I wasn't going to let it go quietly anymore. I was just going to be smarter about how I gathered information before I raised it again. Danny, for his part, wrestled with that conversation for weeks afterward. He told me one night in November that what bothered him most wasn't the vagueness of his dad's answer. It was the speed of it. It was like he had the answer ready before I finished the question, he said, like he'd rehearsed it. I don't know to this day whether Robert had genuinely rehearsed a deflection or whether he'd simply repeated a line Marcus had fed him enough times that it had become reflexive. Either way, it told us something important. Whatever was happening with that power of attorney, Robert had already been coached, consciously or not, on how to talk about it with the rest of the family. That's the moment I started thinking of this less as Marcus is being favored and more as Marcus is managing what his parents are allowed to know. Those are very different problems, and only one of them is something you can fix by asking nicely at Thanksgiving. Over the following 4 months, October 2022 through January 2023, I did something that, looking back, was the actual beginning of the investigation, even though I didn't think of it.
Way back at the time, I started keeping a private notebook. Every phone call with Diane, every offhand comment, every visible financial detail. I wrote it down with a date next to it. Nothing dramatic, just observation. Here's some of what accumulated in that notebook by January 2023. Diane mentioned, almost in passing, that they'd had to let the cleaning lady go, a service they'd had for over a decade, costing roughly $160 a month. Robert mentioned he'd picked up a little consulting work himself post-retirement, doing occasional estimates for a contractor friend. Unusual since he'd fully retired in 2019 and had never expressed interest in going back. On a Christmas visit, I noticed Diane's wedding ring, a ring she'd worn every day of my 9 years knowing her, was missing. When I asked, she said she'd just taken it in to get resized and changed the subject within 4 seconds. Marcus, meanwhile, showed up to that same Christmas gathering with a brand new truck, a 2023 model, the kind that runs $58,000 to $65,000 depending on trim, despite, as far as any of us knew, still being in between things. Diane mentioned during a January call that Robert had started picking up shifts doing part-time inspection work for a local property management company at 74 years old, 6 years after a retirement he'd previously described as the best decision he'd ever made. Each one of these individually has an innocent explanation. A cleaning service is a discretionary expense, easy to cut. A ring can genuinely need to be resized. Retirees genuinely do sometimes pick up part-time work out of boredom rather than need.
I want to be fair about that because I think it's important for anyone watching this who's in the early, uncertain stage of noticing something might be wrong. You don't need to have it all figured out before it's reasonable to start paying closer attention. Suspicion doesn't require proof. It just requires noticing that a pattern of small, individually explainable things has started pointing in the same direction, repeatedly over time. Together, these things formed a pattern that I could no longer explain away as coincidence. And then, in February of 2023, I got the piece of information that turned suspicion into certainty. Diane called me, not Danny, me specifically, on a Tuesday afternoon, in a tone I'd never heard from her before. Shaky, almost apologetic. She asked if we could help her figure something out without Robert knowing, because she said Robert would be upset if he knew she was asking. She'd received a letter from the mortgage servicer on the house, the paid-off house, the one Robert and Diane had owned free and clear since 2009, informing her that the home equity line of credit was now at the limit and that a required payment increase would be taking effect,
raising the monthly minimum from $1,140 to $1,890 because the line had moved from an interest-only draw period into a repayment period. She didn't understand the letter. She read pieces of it over the phone, her voice shaking, and asked, "Honey, does this mean we could lose the house?" And that's when I found the smoking gun. Because as she read me the account number on that letter, I recognized it. I'd seen it before, on that statement I'd glimpsed back in September, sitting on the kitchen counter. The balance in September had been $147,000. 5 months later, in February, the letter she was reading me showed a balance of $149,800, essentially maxed at the full $150,000 limit, and a repayment schedule that was about to nearly double their required monthly payment on a fixed retirement income. A couple with a paid-off house in 2018 was now, in 2023, sitting on $149,800 of secured debt against that same house, at a payment they could not comfortably afford, with no clear accounting of where the money had gone. Danny and I did what I think most reasonable people would do first. We tried to handle it as a family conversation, not a legal battle. We drove down the following weekend. We sat Robert and Diane down at their kitchen table, the same table Danny had done his homework on as a kid, and we asked, calmly, for a full picture: what accounts existed, what the power of attorney covered, where the home equity money had gone, where the proceeds from Diane's mother's house had gone 6 years earlier. Robert got defensive almost immediately. "We don't owe you an accounting of how we spend our own money." That's true, by the way, and I want to be fair to that instinct, because on its face, it's a reasonable thing for a parent to say. Adult children generally aren't entitled to a line-by-line accounting of their parents' spending. The problem is what that reasonable-sounding sentence was being used to shield. Diane, to her credit, looked like she wanted to say more, but every time she started to, Robert redirected the conversation, and eventually she just went quiet. We asked directly whether Marcus had received money beyond what we already knew about: the food truck, the real estate license, the consulting business. Robert's answer: "Danny has needed more help than you two. That's just the truth. You've never needed us the way he has."
And there it was, the justification that had been building for 11 years, said out loud for the first time, framed as a virtue rather than what it actually was. A pattern of one adult child receiving what would eventually be documented as $412,000 in transfers, loans never repaid, gifted vehicles, and directly paid expenses, while the family's total liquid net worth, once around $730,000, had been reduced by 2023 to roughly a $190,000 negative position once the maxed HELOC and the personal line of credit were factored against the remaining assets. We left that conversation with nothing resolved, and a very clear signal that Robert, at least, was not going to volunteer information willingly. That's when I stopped trying to have a family conversation and started trying to build a case. I want to take a beat here because a story like this can start to feel like a spreadsheet exercise, and I don't want to lose the person at the center of it who wasn't me.
Danny grew up believing, in the uncomplicated way kids believe things about their families, that their parents were fair. Not identical in how they treated their two sons, no parent is perfectly identical, but fair. Fair in the sense that if he ever genuinely needed help, it would be there, the same way it had always, apparently, been there for Marcus. Watching that belief come apart in real time in his childhood kitchen over the course of a few months in early 2023 was harder on him than any of the financial numbers. He started sleeping badly. He stopped calling home on Sundays for a stretch of about 6 weeks that spring. Not out of spleen, he told me, but because he genuinely didn't know what to say to his mother that wouldn't turn into an accusation he wasn't ready to make yet. I bring this up because financial exploitation inside a family doesn't just cost money. It costs something closer to a person's sense of where they stand in the world, their place in the story their family tells about itself. Danny wasn't just calculating dollar amounts that spring. He was quietly grieving a version of his childhood that it turned out hadn't been entirely true, and I watched my husband go through that grief in real time, some nights at our own kitchen table, 4.5 hours away from the source of it. It's part of why when people ask me whether this was worth it, the legal fees, the strained holidays, the 2 years of our lives this consumed, I tell them the money was never really the point for either of us. The point was making sure Robert and Diane got to keep their house and making sure Danny finally got an honest answer to a question he'd been too polite to ask for over a decade. Before I walk you through the investigation itself, I want to lay out, because you'll understand the evidence better once you know what we were looking for, how Marcus over 11 years had structured things to stay just under the radar of anyone who might ask questions.
He avoided round numbers and single large transfers. Nothing came out as one dramatic $400,000 wire transfer that would have triggered a bank's anti-money laundering flag or an obvious conversation. It came out in dozens of transactions. $3,000 here for business expenses, $1,800 there for helping with rent, $6,500 for the truck down payment, spread across 11 years, and we'd later discover at least 4 different accounts. He used the power of attorney as both a tool and a shield. Once Marcus held durable power of attorney as of January 2022, any transaction he initiated on his parents' behalf carried a veneer of legitimacy, even the ones that, on closer inspection, benefited him directly rather than his parents. He controlled the information flow. Because Marcus managed his parents' online banking, paid their bills, and lived 9 minutes away, he was functionally the only person who saw the full financial picture in real time. Robert and Diane, particularly as they aged into their 70s, increasingly just trusted the numbers Marcus told them, rather than checking the underlying statements themselves. He leaned on emotional narratives instead of paper trails. Every transfer had a story attached: the business that was about to take off, the truck that was necessary for work, the rent that was just until things stabilize. Emotional narratives are much harder for a family to interrogate than a bank statement, because interrogating them feels like an attack on the person, not a question about a number. This is, by the way, almost a textbook description of what elder law attorneys and adult protective services investigators call undue influence, a legal concept referring to a situation where someone in a position of trust exploits that trust to override an older or vulnerable adult's free will in financial decision-making. It doesn't always require the victim to be unaware. Sometimes, as we'd eventually learn was partly true here, the victim is dimly aware something is wrong and simply doesn't have the tools or the emotional distance to stop it. By March of 2023, Danny and I had a notebook full of observations, a rough sense of dollar figures, and a wall of silence from his parents. What we didn't have yet was proof. That's when I decided I was going to become, functionally, a financial detective, and that's Act 3. I want to be upfront about something. I am not a lawyer, and I wasn't a forensic accountant when this started. I'm a marketing operations manager. What I had, though, was a spreadsheet, a legal pad, and 11 years of Sunday phone calls I could reconstruct from memory, texts, and old emails. The first thing I did was build a timeline. Not an accusation, a timeline. Every dollar figure I could document, every date, every source. I went back through 9 years of texts and emails between me, Danny, and his parents, pulling out every mention of money.
the food truck, the real estate license, the consulting business, the truck down payment, the house sale in 2017, the HELOC in 2018. By the end of March 2023, I had a spreadsheet with 61 line items and a running total that had crossed $260,000 in identifiable transfers, and that was just from what we could remember and document from casual family conversation. I knew, instinctively, that the real number was higher, because a HELOC that had gone from $0 to $150,000 maxed out over 5 years wasn't accounted for by $260,000 in transfers I could name. Here's something most people don't realize. A shocking amount of financial information about property, liens, and legal filings is a matter of public record, freely accessible, and doesn't require anyone's permission to look up. I started with the county recorder's office website, the same office that had generated that letter I'd found in September referencing the power of attorney filing. Most county recorder offices in the U.S. maintain searchable online databases of recorded documents, deeds, mortgages, liens, and yes, powers of attorney, because a POA affecting real estate transactions often gets recorded to be legally enforceable in property transfers. I found it. Recorded January 11, 2022. Durable Power of Attorney for Financial and Property Matters. Robert Whitfield as principal, Marcus Whitfield as agent. Diane was not listed as principal on this particular document, meaning, as we'd later have confirmed by an attorney, that this specific POA only covered Robert's assets, not Diane's, which turned out to matter a great deal later. That gap, the fact that Diane herself had never signed her own POA naming Marcus, became one of the more important legal threads in the entire case. It meant that any transaction Marcus initiated using power of attorney authority on an account that was solely or jointly Diane's wasn't actually covered by any legitimate legal instrument at all. He'd been treating himself, in practice, as having authority he'd never formally been granted over roughly half the family's accounts, which our attorney later argued was itself circumstantial evidence that the help Marcus provided his parents had never really been about formal legal structure in the first place. It was about access, however he could get it, formalized or not. I also searched the recorder's database for anything involving Diane's mother's house, the one sold in 2017. I found the deed transfer, the sale price, $211,500, close to what we'd been told, and buried in a separate filing a quitclaim deed dated 4 months before the sale, transferring partial ownership interest in the property from Diane individually into a joint tenancy that included Marcus's name.
I remember sitting at my kitchen table and reading that filing 3 times to make sure I understood it correctly. Marcus had been added to the deed of his grandmother's house, a house that was Diane's inheritance, not his, 4 months before it sold, which meant that when the house sold for $211,500, a portion of those proceeds, as a matter of legal title, may have been distributed directly to Marcus, rather than passing entirely through his parents' hands. That's when I found the smoking gun, the actual, undeniable one, the piece of paper that turned "we suspect Marcus has been taking money" into "we can prove Marcus has been taking money, and here's the date he legally arranged to do it." At this point, in April of 2023, Danny and I made 2 calls in the same week. The first was to an elder law attorney. I want to stress this specific specialty because a general family law or estate attorney isn't necessarily equipped. Elder law attorneys specifically handle cases involving financial exploitation of vulnerable adults, undue influence, guardianship, and POA abuse. We found ours through the National Academy of Elder Law Attorneys Directory, a free public resource, and scheduled a consultation for $350. The second call was to a forensic accountant, a CPA with a specific credential called CFE, Certified Fraud Examiner, who specializes in tracing financial transactions to identify fraud, embezzlement, and misappropriation. Forensic accountants are expensive. Ours quoted us a retainer of $4,500 for an initial trace, with the possibility of more depending on complexity. But Danny and I agreed that week that we were willing to spend real money to find out how much had actually been taken, because at this point, we weren't doing it for ourselves. We were doing it because Robert and Diane, who were now 74 and 72, were on a financial trajectory toward losing their house in their late 70s, and neither of them seemed to fully understand how close they were to that outcome. That first meeting also gave us something important. In that first consultation, a name for what we were describing: financial exploitation of a vulnerable adult, a specific legal category that exists in some form in the statutes of all 50 states, and in Ohio specifically falls under Ohio Revised Code Section 5101.60 and related elder abuse reporting statutes, with both civil and criminal remedies available. She also told us something that reframed the entire situation for me. The fact that your father-in-law's cognition seems intact doesn't rule out undue influence. In fact, the cases I see most often involve victims who are cognitively fine, but emotionally and logistically dependent on the person exploiting them. That dependency is the vulnerability, not dementia. That first meeting also gave us a practical roadmap, because up until that point, honestly, Danny and I had no idea what the actual mechanics of doing something about this even looked like. The attorney laid out 3 parallel tracks that she explained most cases like ours end up running simultaneously rather than sequentially. Track 1 was documentation, formally engaging the forensic accountant to build an evidentiary record before confronting anyone further. Because premature confrontation, she warned us, is one of the most common ways families accidentally give an exploiter time to destroy or alter records. Track 2 was protective, evaluating whether Robert and Diane needed an emergency modification to the existing power of attorney or a formal revocation to stop any further financial damage while the investigation was underway. This part required Robert and Diane's active cooperation, since neither Danny nor I had any legal authority to revoke a POA on their behalf. Track 3 was reporting, determining, based on what the documentation eventually showed, whether this rose to the level of a mandatory or voluntary report to Adult Protective Services, and separately, whether it warranted a criminal referral to the county prosecutor's office. Hearing it broken down that way into concrete, sequential tracks instead of one overwhelming mess was the first moment since that hospital cafeteria conversation with Diane that I felt like this was actually solvable, rather than just something I was privately furious about. The forensic accountant's process took 6 weeks and required something we needed Robert and Diane's cooperation for: authorization to request full statement histories from their banks, going back as far as the institution's retained records, typically 7 years for most U.S. retail banks under standard record retention practices, though some data went back further through archived statements. This was the hardest conversation of the entire process. We had to go back to Robert and Diane and explain that we believed Marcus had been taking money from them for years, that we had documentation suggesting it, and that we needed their authorization and their bank login information to have a professional trace the full picture. Robert's reaction was anger initially. Diane's reaction, and this is the moment I think about most even now, was relief. She started crying at the kitchen table and said, "I kept telling myself I was wrong. I kept telling myself I was just being a bad mother for thinking it." That sentence has stayed with me longer than almost anything else in this entire story, because it's the sentence financial exploitation depends on. The victim doubting their own read of the situation because the person exploiting them is someone they raised, someone they love, someone they cannot imagine capable of this. With Robert and Diane's authorization, reluctant on his part, immediate on hers, the forensic accountant pulled 7 years of statements across 2 checking accounts, 1 savings account, the HALOC, and the personal line of credit Marcus had apparently helped them open at a second bank in 2020, one neither Danny nor I had known existed until the trace. For anyone curious about the actual mechanics of a forensic trace like this, because I certainly didn't understand it going in, the accountant's process involves what's called transaction categorization and pattern analysis.
Every transaction across every account gets logged into a master ledger, tagged by type, recurring bill, transfer, ATM withdrawal, merchant category, and then cross-referenced against known identities. In our case, Robert, Diane, and Marcus's known accounts, addresses, and even IP-adjacent metadata where available through subpoenaed records. Transfers that don't have an obvious benign explanation get flagged for follow-up, and follow-up usually means requesting the underlying merchant or recipient account information directly from the bank. It's slow, methodical work. 6 weeks for roughly 7 years of data across 5 accounts. And it's exactly the kind of work a family member, no matter how motivated, cannot credibly do themselves, both because of the specialized skill involved and because a report from a credentialed CFE carries evidentiary weight in court that a spreadsheet built by an angry daughter-in-law simply does not. Here's what the trace found, in broad strokes, because the full 34-page forensic report is more detailed than I can walk through line by line. $412,000 total in identifiable transfers, payments, and asset diversions benefiting Marcus directly or indirectly from 2012 through early 2023. $149,800 drawn from the HELOC, of which the forensic accountant could trace approximately $138,000 directly to Marcus benefiting transactions, payments to an auto lender, transfers to Marcus's person's checking account, and payments to a company later identified as an online sports betting and casino platform. The personal line of credit, opened in 2020 with a $35,000 limit, showed a pattern consistent with Marcus making the minimum payments himself for the first 14 months, likely, the accountant theorized, to keep Robert and Diane from noticing anything was wrong, before the payments stopped and the balance began climbing on its own. A portion of the $211,500 from the sale of Diane's mother's house, approximately $61,000, had gone directly to Marcus via the joint tenancy arrangement on the deed, separate from whatever Robert and Diane received. And that's when I found the smoking gun that changed the entire emotional tenor of this investigation, because up to this point, I'd been angry on behalf of Danny and me, angry about favoritism, angry about being kept in the dark. This next discovery made it about something much bigger than sibling fairness. Buried in that forensic report were the transaction descriptions the accountant had flagged as high risk, recurring transfers, many of them late at night, to 3 different online gambling platforms, along with a handful of larger transfers to what turned out to be a cryptocurrency exchange.
Marcus wasn't funding a struggling business anymore, if he ever really had been. By the forensic accountant's estimate, based on transaction patterns from 2019 onward, somewhere between $180,000 and $220,000 of the total amount taken had gone, directly or within 1 or 2 transaction hops, into online gambling and speculative crypto trading. Much of it during a period when Marcus was telling his parents he was building a book of consulting clients. This is where financial betrayal turns into something closer to what addiction researchers describe as a compulsive behavioral pattern. And I want to be careful here, because gambling addiction is a real, diagnosable, and treatable condition, and understanding that doesn't excuse what happened. It explains the mechanism. Marcus wasn't slowly building wealth for himself off his parents' money. He was, by every indication in that trace, losing it, chasing losses, and going back to the same well because it was the only well that would never say no to him. Robert and Diane's retirement, 30-plus years of teaching and contracting, had been, in significant part, gambled away by their own son, one small transaction at a time, while he told them it was rent and a truck and a business that was about to take off. I don't want to make this sound like a straight line from discovery to justice, because it wasn't. There were several points where this whole thing nearly fell apart, or where Marcus nearly talked his way out of it. Near miss 1, Robert almost shut the investigation down entirely. About 3 weeks after the forensic trace began, Robert called Danny and told him to call it off, that Marcus had explained everything to him, that the gambling platforms were a misunderstanding, that Marcus had actually been managing an investment account that just happened to route through those platforms. It took the elder law attorney showing Robert, line by line, the actual account names and licensing information of the gambling platforms in question, publicly registered, easily verifiable, definitely not investment accounts, for Robert to accept what he was looking at. Near miss 2, Marcus tried to get ahead of it with his parents directly. When Marcus realized the forensic trace was underway, he showed up at his parents' house, according to Diane's later account, and told them that Danny and I were trying to steal his inheritance and turning the family against him. For about 10 days, Diane stopped returning our calls. It took a long, difficult conversation and the elder law attorney walking Diane through exactly what undue influence looks like and why isolating a victim from other family members is a documented tactic for that 10-day silence to break. Near miss 3, the statute of limitations. Ohio's civil statute of limitations for financial exploitation claims and related fraud generally runs 4 years from discovery of the fraud, though certain elder abuse-specific provisions can extend that window. Because some of the earliest transactions dated back to 2012, our attorney moved quickly to file before any ambiguity about discovery dates could be used against us, filing the civil complaint in June of 2023, roughly 10 weeks after the forensic trace concluded.
Near miss 4, the one direct confrontation. In late May of 2023, Marcus called me directly, not Danny, me, for the first and only time in this entire process. He was calm at first, almost warm, telling me he understood why this looked bad, that he'd made some mistakes, and that he wanted to handle this like family, not lawyers. He offered on that call to pay back $40,000 over time if we agreed to drop everything and keep it out of the courts. I want to be honest about how tempting that call was in a strange way. $40,000 offered immediately with no forensic accountant, no attorney fees, no courtroom, no strain on Robert and Diane of watching their son face a judge. For about an hour after that call, I genuinely wondered if we should take it. 2 things stopped me. First, $40,000 wasn't 10% of what the forensic trace would eventually document. It was an opening offer designed to make the problem disappear cheaply, the same way every prior loan, help, and investment had been designed to make a smaller version of this problem disappear cheaply for 11 years. Second, and more importantly, $40,000 did nothing to protect Robert and Diane going forward. It didn't remove Marcus's power of attorney, it didn't fix the maxed HELOC, it didn't stop the pattern from continuing quietly for another 11 years. It just bought Marcus silence one more time, the exact same way he'd been buying it since 2012. I called our attorney the next morning and told her about the offer. Her response has stuck with me since. That's not a settlement offer, that's damage control. There's a difference. And the difference is whether it actually fixes anything. We didn't take the deal. Each of these near misses could have ended the case. Robert almost pulled the plug based on Marcus's explanation. Diane almost cut contact based on Marcus's framing. Marcus almost bought his way out of real accountability for less than 10 cents on the dollar, and a slower attorney could have let a filing deadline lapse. None of those things happened, but I want you to sit with how close they came to happening, because that's usually the difference between exploitation that gets caught and exploitation that gets away with it. Not the absence of doubt, but whether the people around the victim keep pushing through the doubt anyway. By July of 2023, we had a filed civil complaint, a forensic accounting report, a documented power of attorney timeline, and a deed transfer with Marcus's name on it 4 months before a house sale that benefited him directly. We also had something else. Adult Protective Services had opened an independent investigation, triggered by a mandatory report the elder law attorney filed on Diane's behalf, given her age and the documented pattern of exploitation. The case was no longer just a family dispute, it was now simultaneously a civil matter and a criminal referral. That's Act 3, In Act 4, I'll walk you through exactly what happened when this went in front of a judge, the restitution, the criminal charges, and the twist about what that gambling money actually turned into, because it's not the ending you're expecting. Adult Protective Services investigation, which ran parallel to our civil case, concluded in September of 2023 with a formal finding of financial exploitation of a vulnerable adult, specifically citing Robert's status as a stroke survivor with documented post-stroke fatigue and the power of attorney relationship as aggravating factors. That finding was referred to the county prosecutor's office. I want to be clear about something here because true crime content sometimes glosses over this. Not every APS referral results in criminal charges. Prosecutors weigh a lot of factors: the strength of documented evidence, the willingness of the victim to testify, resource constraints, and whether a case is more efficiently resolved civilly. We got lucky, in a sense, in that our case had something a lot of financial exploitation cases lack: a clean forensic paper trail with dates, dollar amounts, and a smoking gun deed transfer that was almost impossible to explain away as innocent. In November of 2023, the county prosecutor's office filed criminal charges against Marcus under Ohio's Theft from Elderly or Disabled Adult Statute, Ohio Revised Code Section 2913.02, with an enhancement specific to victims 65 and older, which elevates the degree of the offense and the potential penalty given the dollar amount involved. In Ohio, theft exceeding $150,000 from an elderly victim can be charged as a felony of the first degree. Marcus was formally charged in case number CR 2023/XXXX, identifying details withheld, with felony theft from an elderly person and a separate count of forgery relating to a document the forensic accountant had identified during the trace, a bank signature authorization that investigators determined had been altered to add Marcus as an authorized user on one of Robert and Diane's accounts back in 2019, predating the actual power of attorney by nearly 3 years. And that's when I found the smoking gun that turned this from a family dispute into a criminal case. The signature on that 2019 authorization form wasn't Robert's and it wasn't Diane's. A forensic document examiner retained by the prosecutor's office compared it against verified samples from both parents and identified inconsistencies in stroke pressure and letter formation consistent with forgery. That single document, 3 years before the legitimate power of attorney was ever filed, was the difference between favoritism and felony. While the criminal case built, our civil complaint, filed on Robert and Diane's behalf, with Danny and me supporting as documented witnesses, and the ones who'd initiated the forensic trace, proceeded through discovery. This is where things got, frankly, uncomfortable for Marcus in a way that made the fiction he'd built for 11 years impossible to maintain. Discovery in a civil fraud and exploitation case allows both sides to subpoena records, bank statements, account applications, transaction histories, directly from financial institutions, bypassing any need for the other party's cooperation. Marcus's attorney tried, initially, to argue that some of the older transactions, particularly from 2012 through 2016, fell outside any actionable window and amounted to gifts freely given by loving parents, which is a real and sometimes valid defense in family financial disputes. What undid that defense wasn't the old transactions, it was the newer ones, specifically the gambling platform transfers, the altered signature authorization, and the quitclaim deed added 4 months before the sale of Diane's mother's house. Gifts freely given don't typically involve a beneficiary adding himself to a deed shortly before a sale, and they don't typically involve forged authorization documents. Marcus's attorney requested a settlement conference in January of 2024, which is often a sign in civil litigation that the defending party sees the writing on the wall and wants to control the outcome, rather than risk a judgment at trial. In March of 2024, 2 things happened within about 3 weeks of each other. First, the civil case settled.
The settlement, structured as a consent judgment, meaning it's enforceable in court the same way a trial verdict would be, required Marcus to pay restitution of $340,000, structured as an immediate lump sum payment of $85,000, funded by liquidating the truck, a small investment account, and a loan Marcus's then-fiancé's family provided, followed by a court-monitored payment plan for the remaining $255,000, secured against Marcus's future wages and any future inheritance over a period not to exceed 12 years, with interest. I want to be honest, that $340,000 of $412,000 isn't everything. The forensic accountant and our attorney were both clear from early on that recovering 100% of exploited funds is rare, particularly when a significant portion was lost to gambling rather than converted into recoverable assets like property or a business. $340,000 recovered, with a legally enforceable long-term payment structure for the remainder, was, according to our attorney, a genuinely excellent outcome for a case of this type. Second, and separately, Marcus's criminal case resolved via a plea agreement. He pled guilty to a reduced charge, theft from an elderly person, felony of the third degree, in exchange for the forgery charge being dropped, and his agreement not to contest the terms of the civil settlement. His sentence, handed down in April of 2024, was 5 years of community control, Ohio's version of intensive probation, a mandatory participation in a state-certified problem gambling treatment program, and a formal restitution order matching the civil settlement. I was in that courtroom. Danny was too, sitting one row behind his parents, close enough to reach forward and put a hand on his mother's shoulder when the judge read the restitution figure aloud. Robert didn't speak during the hearing. He declined the opportunity to give a victim impact statement, telling us privately he didn't have the words for it yet. Diane did speak. Her statement was 4 sentences long, and I still remember the third one. I love my son. I also love my house. And for a long time, I didn't understand why I couldn't have both. I understand now. The judge, before reading the sentence, addressed Marcus directly, noting for the record that the court had reviewed the forensic accounting report, the documented pattern spanning 11 years, and the letter from his treatment counselor, and that while the court took the gambling disorder diagnosis seriously as context, it did not, in the judge's words, diminish the deliberate and sustained nature of the deception involved, particularly the falsified 2019 authorization. That sentence, more than any dollar figure, felt like the moment the record finally matched what Danny and I had spent 1.5 years proving. I'm not going to pretend the family didn't take a hit socially and reputationally, because in a small Ohio community, a felony theft case involving an elderly stroke survivor doesn't stay quiet. The local paper covered the sentencing. Court proceedings are public record, and this one, given the elder abuse angle, drew a short article. Marcus's engagement, the one funded partly by his fiancée's family bailing him out with that initial $85,000, ended within 4 months of the sentencing. He lost his real estate license. Turns out most state real estate commissions require disclosure of felony convictions, and Ohio's Division of Real Estate initiated a licensing review that resulted in permanent revocation in late 2024. Here's the part that actually matters most to me, more than any of the legal mechanics. What happened to Robert and Diane? With the $85,000 lump sum and the beginning of the structured payment plan, combined with the reverse mortgage counseling session our elder law attorney recommended, not a reverse mortgage itself, just a counseling session to understand all their options, Robert and Diane were able to pay off the maxed HELOC entirely, using $85,000 of the lump sum plus roughly $65,000 they'd been sitting on in a CD they'd forgotten they still had, untouched, because Marcus, interestingly, had never had signatory access to that particular account. They kept the house. Robert's HELOC payment, once the balance was cleared, dropped back to essentially nothing. Diane went back to some casual substitute teaching, not out of financial desperation, but she told me, because I wanted something that was just mine again. Danny and I also did something we hadn't originally planned to do. We set up a legitimate durable power of attorney and healthcare directive for both Robert and Diane, this time with Danny named as co-agent alongside a neutral third party, a licensed fiduciary the elder law attorney recommended.
Attorney recommended specifically so that financial oversight would never again rest entirely with one family member with zero outside accountability. I remembered the day we signed those documents at the attorney's office. A plain conference room, fluorescent lights, a stack of paper an inch thick. Diane cried again, but differently this time. Not the tears from the hospital cafeteria or the ones at the kitchen table when she said she'd been telling herself she was a bad mother. These were quieter. She squeezed my hand afterward and said, "I feel like I can breathe again." That sentence is the actual ending of this story as far as I'm concerned. Everything else, the restitution schedule, the sentencing, the dollar figures, was in service of getting Diane back to a place where she could say that sentence and mean it. I promised you a twist about what the money was actually used for, and here it is, because I think it's the piece of this story that changes how you understand the whole thing. When the forensic accountant's final supplemental report came back, this one requested by Marcus's own defense attorney during settlement negotiations, ironically, to argue for a lighter sentence based on compulsive behavior consistent with a diagnosed addiction, it included a letter from a licensed gambling addiction counselor Marcus had begun seeing in late 2023, after the civil complaint was filed but before any plea deal. That letter documented something that reframed for me 11 years of behavior I'd read as pure greed, a diagnosed gambling disorder per DSM-5 criteria that the counselor believed had likely been active in escalating form since at least 2015, around the time the consulting business quietly folded and the pattern of transfers accelerated. The twist isn't that Marcus is secretly sympathetic and everyone should feel bad for him. I don't think that, and I don't think you should either. Diagnosed addiction explains a mechanism. It doesn't erase 11 years of deliberate concealment, forged documents, or the calculated decision to add himself to a deed 4 months before a house sale. Addiction is not a legal defense to forgery. But the twist is this. The $412,000 wasn't building Marcus's secret empire, a hidden property, an offshore account, or a comfortable second life. Almost all of it, according to the forensic trace, was gone, genuinely, completely gone, lost across 3 online gambling platforms and a handful of failed crypto trades, chasing losses that never recovered. There was no secret fortune to seize. There was no hidden mansion. There was just a hole. And the restitution order Marcus is now paying off over the next 12 years isn't money he has, it's money he now owes out of future wages for the rest of his working life. Which means Marcus didn't get away with $412,000. He didn't even keep it. He destroyed it, gambling loss by gambling loss, and is now the one paying the actual long-term price for it. A felony record, a lost fiancé, a lost professional license, and a restitution debt that will follow him well into his 50s. That, to me, is the most satisfying kind of justice available in a case like this. Not a villain who cackles his way to a beach house, but a person forced, finally, to fully own the consequences of 11 years of choices, in front of a judge, in public record, with a repayment schedule that doesn't go away just because he wishes it would. If you take one thing away from this story, I want it to be this. Financial elder exploitation almost never looks like a stranger calling from a fake IRS number. It usually looks like family. Here are the patterns worth watching for, in your own family or someone else's. 1. Unexplained changes in a parent's standard of living. If a financially stable retiree suddenly can't afford things they used to easily afford, canceling services, mentioning things being tight, that's worth a direct, gentle conversation, not an assumption. 2. One adult child with exclusive control over a parent's finances. Whether it's online banking access, bill pay, or a power of attorney, exclusive, unsupervised control by a single person with no outside check is a structural risk factor, regardless of that person's intentions. 3. Isolation from other family members. If one sibling or caregiver starts actively discouraging a parent's contact with other family or reframing other family members as untrustworthy or unnecessary, that's a documented tactic associated with exploitation, not just sibling rivalry. 4. Financial decisions made in secrecy or explained in vague emotional terms instead of specifics. "We're just helping your brother with some things" is not an accounting. You are allowed to ask for specifics, gently, more than once. 5. Power of attorney or account changes that happen without full family awareness, especially after a health event like a stroke, a fall, or a new diagnosis, when a vulnerable adult is most susceptible to influence. 6. A sudden, unexplained lifestyle upgrade in the person with financial access, a new vehicle, new debt, new business that never quite produces receipts or clients you can verify. It's easy to explain away a nicer truck or a confident story about a deal that's about to close. I know because I explained it away myself for years. But lifestyle inflation that outpaces any visible, verifiable income source is one of the single most reliable indicators forensic accountants look for when a family finally does bring one in. If you're watching this and something feels familiar, here's where to actually start, in roughly the order we wish we'd known to follow. Start quiet, not loud. Before you confront anyone, gather what you can independently verify. Mail, statements you're shown in passing, public records, the same way I built that first notebook. Premature confrontation gives a bad actor time to alter or destroy records, and it can
Also, painfully, give them time to isolate the vulnerable parent from you before you have enough to act on. Check your local county recorder's office website. Most are free and public, and you can search for any powers of attorney, deeds, quitclaim filings, or liens involving your parents' names. It takes 15 minutes and costs nothing, and it was the single highest value 15 minutes I spent in this entire process. Contact your state's Adult Protective Services if you have a genuine, evidence-based concern. Reports can typically be made anonymously, and APS agencies are legally required to investigate credible reports involving elderly or otherwise vulnerable adults. You don't need proof to make a report. You need a good faith, reasonable concern. The investigation is their job, not yours. Consult an elder law attorney before a general family lawyer. The National Academy of Elder Law Attorneys maintains a free public directory at naela.org, and many offer low-cost initial consultations specifically structured around exploitation concerns. This single phone call is what turned our situation from a bad feeling into an actual plan with actual steps. Budget for a forensic accountant if the numbers are large enough to justify it. It felt like an enormous expense at $4,500 for the initial retainer. It ended up being by a wide margin the best few $1,000s we've ever spent because it converted a family argument into a court-admissible record. And if you're the parent, not the adult child, consider a multi-agent power of attorney structure, where more than one person or a neutral licensed fiduciary has visibility and shared authority over major financial decisions. It's not about distrust of any one child. It's about building a system that doesn't rely on any single person's character holding up perfectly for the rest of your life. Because, as this story shows, sometimes even people who genuinely love their parents can be fighting battles, like addiction, that make them unreliable stewards of trust, whether they intend to be or not. Before I wrap up, I want to answer a few questions I know are coming, because I've told a shorter version of this story before, and these are the ones people always ask. Why didn't you just call the police the moment you found the HELOC statement? Because, honestly, we didn't have anything a police report could act on yet. A statement showing a large balance isn't evidence of a crime, it's evidence of debt, which is not illegal. Law enforcement and prosecutors need documented intent and a traceable pattern, which is exactly what the forensic accounting process exists to build. Going to police too early with too little is one of the most common ways these cases get dismissed or shelved. Couldn't Robert and Diane have just said no to Marcus at any point? In theory, yes. In practice, this is the core of what undue influence means as a legal and psychological concept. It's not that the victim has no free will at all. It's that their decision-making is being systematically distorted by dependency, isolation, and trust. Robert and Diane weren't incapacitated. They were, for over a decade, being told a consistent story by the person they trusted most to manage their day-to-day financial reality. And that story was engineered, whether consciously or through the fog of addiction, to keep them from asking the right questions at the right time. Did Marcus ever apologize? Once, in a letter sent to his parents about 2 months after sentencing, not to Danny or me. Diane described it to me as an apology with a lot of explaining mixed in. I'll let you draw your own conclusions about what that means. What happened to the joint tenancy on the grandmother's house? Did that get separately unwound? Yes, as part of the civil settlement, the $61,000 Marcus received through that quitclaim deed arrangement was folded directly into the total restitution figure, and our attorney made sure the settlement specifically addressed and closed out that transaction, so it couldn't be argued later as a separate, protected gift. As of the time I'm recording this, Robert and Diane's house is paid off again. Marcus is 14 months into his restitution schedule and, according to Diane, current on every payment. He completed the initial phase of his gambling treatment program and, per the terms of his community control, submits to periodic financial monitoring as a condition of avoiding the suspended 30-month sentence. Danny and Marcus are not close. I won't pretend this story ends with a tidy family reconciliation, because it doesn't. Not yet, and maybe not ever in the way it used to be. But Robert and Diane are financially stable, genuinely for the first time in nearly a decade, and they know it, and they know why, and they've never once told us again that asking questions about money isn't our business. If this story hit close to home, if you've watched a family member get exploited, or if you've been the one asking uncomfortable questions nobody wanted to answer, I want to hear about it. Tell me what happened in the comments. What warning signs did you miss? What made you finally start asking questions? And if you're in the middle of a situation like this right now, know that it is never too late to start pulling the thread. If you found this story valuable, subscribe for more real financial justice stories, cases where people fought back against fraud, exploitation, and betrayal, and won. New stories drop every week, and I promise you, they only get more satisfying from here. Thanks for watching. I'll see you in the next one.